Assalamualaikum and a very good day to Dr. Mohammad. I am Shariani Binti Zaidin Shah, student number 2022-685768 and student from BA 243 Bachelor Degree in Human Resource Management. Today, I will present you my personal portfolio based on two topics that required in the individual assignment of HRM659 Industrial Relation. The two topics are constructive dismissal in Malaysia. What should you do when your employer forces you to resign? And the effect of soft skill on Gen Zs in industrial relations in Malaysia. Without further ado, let's continue. The first article that will be discussed is titled Industrial Court Awards 6 Consultant RM 793,000 for Constructive Dismissal. This case was reported by Free Malaysia Today on 21st May 2024. 6 consultants filed a case against their former employer, claiming they were forced to resign due to the employer's conduct. That is what we refer to legally as constructive dismissal. The industrial court agreed with them and awarded a total of RM 793,000 in compensation. But how the industrial court can agree to that? So, let's look at the central issues of this case. Firstly, the constructive dismissal itself. This occurs when an employee resigns because the employer's actions have made continued employment impossible or unreasonable. It is not a resignation in the true sense, but a dismissal in law. Next, the employer's conduct. The article suggests that the employer's action led to a situation where the consultants felt compelled to resign. Such actions might include significant changes to job roles, demotion, reduction in salary, or other unilateral changes to employment term without the employee's consent. These actions can be deemed as fundamental breaches of the employment contract. And third issues highlighted here is the industrial court decision, which is the compensation awarded. The industrial court awarded RM 793,000 to the 6 consultants, indicating that if found merit in their claims of constructive dismissal. This compensation likely covers back wages and possibly compensation in lieu reinstatement, depending on the specifics of the case. Moving on to the next discussion, which is the applicable statutory law. From this article, there are 2 statutory laws that can be applied. Firstly, the Industrial Relations Act 1967 or IRA. Under the IRA 1967, there is Section 20, Subtopic 1, which allows employees who believe they have been dismissed without just cause or excuse to make representations to the Director General for Industrial Relations. Next, Section 20, Subtopic 3, whereby it empowers the Director General to refer the representation to the Industrial Court if the matter is not resolved. The second statutory law is Employment Act 1955. So basically, Employment Act is the main law governing employment terms for Peninsular Malaysia. It covers contracts, working hours, rest days, termination, wages, maternity leave, and many more. Moving on to the second article entitled Gen Z More Likely to Engage Unethical Conduct Workplace. The article from Astro Awani discusses findings from a report by LRN Corporation highlighting ethical challenges in the workplace, particularly among Gen Z employees. The report indicates that 22% of Gen Z's respondents admitted to engaging in unethical conduct in the past year, compared to 9% of baby boomers. So, there are 2 highlighted issues from this article. Firstly, workplace misconduct. The prevalence of unethical behaviors such as harassment, discrimination, conflict of interest, and health and safety violation raises concerns about adherence to workplace standards and the effectiveness of existing policies. Meaning by that, employees that may not be following the proper rules or ethical behavior give impact, whereby the current policies or rules may not be working well enough. The second issue is the generational attitudes toward ethics. The growing generational divide in workplace behavior, particularly among Gen Z employees, highlights the evolving challenges organizations face in maintaining ethical standards. Research indicates that younger workers may be more inclined to justify bending or breaking rules to meet objectives, which raises important questions about the effectiveness of current ethics policies. This trend suggests that organizations must go beyond traditional rule setting and focus on meaningful ethical training and cultural integration. By actively engaging younger employees through transparent communication, real-life scenarios, and input values, companies can foster a stronger, more consistent ethical culture that resonates across all age groups. As for the applicable statutory law, there are two, which are Employment Act 1955 and Occupational Safety and Health Act 1994, which is OSHA. Same as the previous act that I have mentioned, which is Employment Act, this act governs the terms and conditions of employment, including provision related to misconduct and disciplinary action, while OSHA mandates employers to ensure the safety, health, and welfare of employees at the workplace, which encompasses preventing health and safety violation. Next, I will compare and contrast both articles, which is the constructive dismissal and the effect of soft skill on Gen Z in industrial relations. So, both articles examine critical issues within the modern workplace, particularly in the Malaysian context. They highlight the evolving challenges that employers and employees face concerning legal rights and ethical behavior. While the first article focuses on a legal dispute where 6 consultants were awarded compensation for constructive dismissal, the second article explores research findings indicating that Generation Z employees are more likely to engage in unethical workplace conduct. Despite this shared focus on employment practices, the nature of each article differs significantly. The constructive dismissal case represents a reactive legal process where the industrial court intervened after the employer allegedly breached fundamental employment terms. In contrast, the article on Gen Z behavior emphasizes proactive ethical management, urging organizations to strengthen reporting mechanisms and compliance cultures before misconduct occurs. In essence, the first article deals with the legal consequences of poor employer practices, while the second offers insights into preventative strategies for managing workforce behavior. Together, they present a comprehensive view of how legal frameworks and ethical standards must work in tandem to promote a fair and productive work environment. As for the conclusion, these two articles highlight the critical balance between legal compliance and ethical behavior in the workplace. The constructive dismissal case demonstrates how breaches of employee rights can lead to serious legal consequences, while the research on Gen Z ethics shows the importance of fostering a strong ethical culture to prevent misconduct. Together, they emphasize the need for employers to uphold fair treatment and clear policies, and for employees to act responsibly within professional environments. That's all from me. Thank you.